live with Andrew Torrez of the Opening Arguments podcast in the law offices of P. Andrew Torrez. We're doing our June NaMo home evening. This is our monthly, sometimes monthly hangouts where we invite really cool people on and ask them questions and talk to them. And hopefully when it comes to Andrew, maybe tap a little bit into their expertise. So Andrew, thanks so much for joining us tonight.
Well, Bryce, thanks as always for having me. Although whenever the criterion is really cool people, I'm a little bit concerned that my invite get mixed up with someone else's. But
I think you might be selling yourself short, especially with that beard you're rocking now.
Oh man,
you
it's
turned up the
feeling
cool
good.
factor by about 11 points there. So,
All right.
As your expertise in this field of podcasting is so very high in demand and low on supply, I figured we have a lot of questions to get to. So how does it sound just jumping right in? Does that look good?
Yeah, let's go for it.
All right. So we received a number of questions first on the Patreon only thread. This is on patreon.com/nakedmormonism. People who support the show, of course, they get an opportunity to comment on the post for this. And we had quite a few questions that rolled in on that. So let's go ahead and get started first with, and also preface this. Some of these questions are Mormon history. Some of them are legal. Most of them are Mormon history and current Mormonism with a legal bend to them. So we may be splitting up the answer between Andrew and I, dependent on kind of what we have to tap into here. So the first one that I'm going to ask, this might tap into your knowledge of 19th century history as well, Andrew. This is from Walker, and he asks, what were Smith's chances of winning the presidency?
So I think that would depend on the year, right? Like, but no. The way in which right, I'm tempted to say 0, because I think that's right. But let's play this out a little bit, right? So. Okay. Here are all the different factors that I can think of that go into how presidential candidates were chosen and then elected in the 19th century, right? So keep in mind, you did not have direct election of senators yet in the 19th century. You had, I think, sort of the more robust kind of framers' envisionment of the Electoral College, right? So you had, was it 1828 that was split like 5 different ways? I know 1876, this, was the Tilden and Rutherford B. Hayes. That would obviously be too late for Joe. So it strikes me in listening to your show, Bryce, that I have this picture of history of the Mormons being kicked out of every place that they went to, right? Being feared and hated and despised for being the other, right? And and I thought, I was actually talking about this with my they're not here right now, but my still true believing Mormon in-laws are visiting us, and I was, because we've been able to push the envelope a little bit. I was talking about how I was doing this Q&A tonight, right? And I said,
okay,
now, don't think the show is for you. It's hosted by an ex-Mormon, and it's, from a secular and critical perspective. But then, like, when I was giving an example of kind of the storytelling of history, right, which I think you do so well. I was talking about the Missouri extermination order, right? Mm-hmm. And so that way I could talk about the dynamics of that, because look, that was a pretty safe subject, because it's kind of hard not to feel for the Mormons in that that situation, right? And to say, look, like, the dynamics are, you have the underlying, you have the Trail of Tears, you have all this land opening up, and you have the Mormons coming in and, as a cultural other, really threatening folks politically. All of that, I'm just restating naked Mormonism. So that I've done no work on that. But that underlying dynamic leads me to believe that party bosses would, and who knows what banner Joe Smith would run under, but that they would do everything in their power to use every procedural mechanism available to, deny access to, sort of rig to make sure that electors who, if if there were popular votes that went to Joseph Smith, that electors got appointed who would vote for someone else. I mean, it is almost impossible to imagine that that coming through. The flip side of that is you are talking about a time, right? You're talking about the death of the Whigs, the rise of the Republicans. You're talking about American politics being in flux, and so he'd do better than his counterpart today. How about that?
Right. Well, and he did hold to some popular ideas at the time, right? Notably, assimilation and culturally Christianizing the Native Americans. I mean, that was kind of the central crux of the Book of Mormon itself. He was for a federal bank, which was also one of these big party line issues. Yep. So, I mean, it is interesting also his presidential pamphlet that was published in 1844 as, the advertisement for his campaign. It included buzzwords from both sides of the aisle. And, people were disenchanted with the Whigs at the time. And like you said, it's the death of the Whigs. It was the corrupted party that used to be the backwoods country, support.
Right. But now, I mean, let's not go too far with that. Joseph Smith was the prophet and head of a what people at the time believed to be a non-Christian denomination. JFK in 1960 had to go on television and assure folks that he would not take marching orders from the Vatican.
Right.
How on earth does somebody who gets his marching orders from God, which is to say he makes them up at his head, how can you say, well, I promise, I solemnly swear that I believe in an America in which the separation of church and state is absolute, meaning that when God tells me to write in old-timey English, then that's not a political thing. You can't do it. So we had an unbroken string of Protestant presidents until 1960, and it is. I do not think, however, and Joe Smith must have been a damn charming individual, right? That's another thing that comes through loud and clear from listening to your show. But I don't care how fucking charming that dude is. He is not winning in 1852. So
right. I always see it as Joseph Smith was definitely an ideas guy. He had the charisma. He could obviously connect with a crowd, but much more effectively connect to somebody at an individual level. But those aren't necessarily skills that map to being a successfully elected president or an effective president, right? He wasn't very good at paying his bills. He wasn't very good at keeping track of everything that he had, all the balls that he had up in the air. He was not a great candidate.
Look, take all of those things and add in mainstream Protestantism, and you get William Jennings Bryan, right?
Okay.
Who was a 3-time unsuccessful, the Buffalo Bills of failed presidential candidates. Right, but he was all of those things, right? Super charismatic religious leader, opinion leader in evangelical circles, populist. He was a free silver candidate. I mean, that was an issue that hadn't arisen by the time that Joe was there. But very similar ideologically, and not the head of a cult.
Right.
So
right.
So yeah, I'm taking the under on Joe Smith's chances. How about that?
Okay, fair enough. We also have Randy commented in the YouTube section, yet Bryce, we have Trump. So you're right. Maybe we shouldn't be using people who, metrics of effectiveness or, worthiness to be a president in the age of Trump. Okay. Look,
can I, because this is my show. Can I,
do it.
There's the reference to my show, Opening Arguments. The founding fathers definitely thought that they put enough checks in place to not get a Trump, right?
Right.
When you read the Federalist Papers, you read the sections, I think it's 71 to 73, I could be wrong, but you read the sections that Hamilton wrote about how the president would be elected, and it basically reads come on, it's not like we would ever elect a corrupt, criminally insane game show host to run this country or something like that.
No.
Yeah, it's it breaks your heart. Anyway,
only in the alternate universe in which we live. Okay. So this is actually this question is related once again from Walker. He asks, the Council of 50, which that's Joseph's theocratic, government that he established, was trying to draft a new constitution, one that made Smith God on earth. Assuming Smith won, how would the Mormons have accomplished these goals of court in the early days of the nation? So if they had a new constitution, how would they go about trying to implement it, I guess?
So I guess my question there is new federal constitution or new state or territorial constitution?
New federal constitution.
So, okay. So let me, no. I'm totally unprepared for this question, but let me take two swings at it, right? So the first is that it is Article 5 of the Constitution is what provides for the mechanism for amending the Constitution.
Right, constitutional conventions.
And it gives you two options, right? It says that amendments to the Constitution can originate either from the legislature, right, which is how we've gotten every constitutional amendment so far, or from a constitutional convention, from an Article 5 convention. And I actually have talked about this at some length on OA, but the important thing is that there is some historical anti-precedent, right? I don't want to overplay this too much, right? But the Constitution says that it can only be amended by a vote that is then ratified by the legislatures of 3/4 of the states, right? Which in 1845 that would be what, about 17? I don't have the numbers in front of me, right?
Plus a number of territories as well. But yeah.
Well, no, territories don't get a vote.
Oh, okay.
Right. Yeah, it's only states.
That's right. Or else, Puerto Rico would have a vote.
Exactly right. Anyway, the point is that seems like a pretty robust safeguard. But as I pointed out to Lawrence Lessig when he was on my show defending the Article 5 Constitutional Convention process, the Articles of Confederation provided a mechanism that said that any amendments to the Articles of Confederation had to be unanimous. And so Rhode Island, so the Constitutional Convention in Philadelphia that produced the Constitution we have now, Rhode Island boycotted that convention. Mm-hmm. They were like, you know what? We're not into this. We're not going to vote for whatever comes out of this anyway. So we're not sending anybody. And whenever you send something our way, feel free to mark it, veto. And they thought that the old rules would apply. And as it turns out, when everybody else agrees to change the rules, if you're not there,
you don't get a seat at the table.
You don't get a seat at the table. Yeah. And so Rhode Island actually, hi, Law Dog. Rhode Island was absorbed into the Union by the provisions of the Constitution that provided for ratification. But they were the last state to ratify the Constitution. And so all of that, as a little bit of history, is your best bet to finagle the new Constitution would be some kind of Article 5 convention, and then hijack that convention.
Well, that's kind of the thing is we're assuming that even at the onset that at some point the Mormons are going to be playing by the rules for this hypothetical, thought exercise. But that probably was never going to happen, right? I mean, let's suspend reality and say that Joseph Smith did get elected to be president. He was well prepared and ready to lead a military coup of the current powers that be, the contemporary powers that be. So it's like, we could talk about it like, calling together a constitutional convention, but that doesn't really matter when the entire country is thrown into turmoil because of a revolution, a religious revolutionary. So those rules don't seem to apply.
And think about where the I'm getting some noise in the background now.
Yeah, sorry, I'm trying to find it here.
Okay. Anyway, so what I was going to amplify that a little bit is superimpose kind of the beginnings of the underlying social demographics that led to the Civil War on top of all of this, right? So let's say Joe gets elected in 1852. Excuse me, sorry. At this time, the nation's military academies are located in Virginia, right? So, would you be able to orchestrate this through controlling a majority of the northern states and, ignoring a secessionist South? I don't know. And now it feels like I've lost everybody.
No, I'm still here. I had to mute Timothy there. So if you're ready if you'd like to chime in at any point, let me know, Timothy. So also related to this, this is part of Joseph Smith's campaign platform, is a federal bank at the time. The Kirtland Safety Society, the banknotes.
Yep.
The legality of the banknotes that were being issued, these proprietary banknotes, was something that was in a constant state of flux. And notably, Andrew Jackson, of course, signed the Specie Circular in 1836, I believe it was, which made it so that the government would no longer accept these proprietary banknotes as tax dollars. That you had to actually pay in gold and silver your tax bills. So another question from Walker says, the Smith banknotes, what was their worth during circulation? We can discuss that. It's probably more fielded towards me. What, if anything, is their worth now? Great examples of them are going for about 15 grand right now. And then final question, what are the legalities of making banknotes during this era?
Okay, so I really want to hear your take on that, but I want to ask a question of you first, Bryce.
Yeah.
You've described it on the show how they changed the name to the Kirtland, like anti-banking society.
Yeah.
Did they really just like write that on the notes? Like what did they do to change the notes to try and get around that prohibition?
Well, Oliver Cowdery was initially sent to New York to have the plates made, the printing plates for it made. And he did that at the same time that I believe was William Wines Phelps was in Cleveland, I believe it was.
I lost you.
Sorry, there we go. Sorry, my bad. So that happened at the same time. I think William Wines Phelps was in Cleveland trying to acquire the bank charter for it. When they both came back, Oliver Cowdery and Phelps came back about the same time. Cowdery had the plates, the picture printing plates, and they began printing money. And then they were denied charter status. So basically, they did just that. They engraved anti in front of bank and ing at the end of bank. And continued to print their money. So you can find examples that are Kirtland Kirtland Bank Society, Safety Society, and then there's Kirtland Safety Society Anti-Banking Company. And they're, it's the same exact dollars, or not dollars, but the same notes, but you just have anti and ing before and after. And the actual Kirtland Safety Society bank notes, those are worth a lot more because there were a lot fewer of them that were printed.
Sure.
Yeah.
That makes sense. No, that's really fascinating. Like my father collects coins, and I had a grandfather who collected stamps, and I'm just thinking that, like, the same principles that apply when you're talking about rare stamps or kind of bizarre bills and things like that. And everybody I know would love to have a copy of one of those that was in circulation.
Well, and I mean, you couldn't tell Joseph Smith that one of those is worth 15 grand, 180 years after his death. I mean, it would blow his brain out of his face, right? Because they couldn't give them away in Kirtland.
Well, yeah, and that's right, and that's the thing that if there's a limit to how much you can persuade sort of even those who believe in ancient Jews coming over in wooden submarines, right?
Yeah. Nice little perspective shift, but yes, you're right.
There is my favorite author, Joseph Heller, wrote a book called Picture This, which is about it's ostensibly about the painting, the Rembrandt painting, Aristotle Contemplating the Bust of Homer, the really famous one. But it's really just kind of a rambling, delightful mess. And but one of the things he says in there is he talks about how Rembrandt, late in his life, engaged in the act of trying to rebuy all of his paintings that were in circulation to create an artificial scarcity and
Right.
thereby make himself wealthy. And after describing that, Heller then just dryly notes, this scheme would have paid off handsomely had Rembrandt lived to be 200. So,
Bingo.
yeah.
Exactly.
Yeah, I think the question was, is any of this legal? So, right, the answer there is kind of a gray area, right? What you can't do is indicate that this is, a legal tender for public and private debts. But that's less of an issue in the mid 19th century, right? Like,
Right.
you don't have a federal income tax, right? You have state sales taxes. But, so if you have kind of an enclosed commune and everyone agrees that these worthless pieces of paper are not worthless, it would be very difficult for me to imagine, right? I mean, suppose that it had worked out, right? Suppose that they'd come back, they'd circulated the ABS notes, and everybody just agreed, like, okay, yeah, we're going to get payment in that, we're going to take it, it would to have, so in order to challenge that, right, you would have to have standing, right? You'd have to show
Right.
that you were injured. And now, look, inevitably, where you would get injured is somebody living in, Nauvoo or whatever, would then try and pay somebody somewhere else and be like, oh, here, have
Right.
$1. And they would be like,
And it's not $1.
this is nothing.
Yeah. Well, and
But
to be clear,
until
like,
that happens, yeah.
because people had standing and were suing Joseph and Sidney Rigdon, that's what forced them to leave Kirtland and go to Missouri in the middle of the night, right? That, like, there were multiple active lawsuits against both of them that caused them to flee because of the Kirtland Safety Society, among many other things too.
I did not know. Because of that. I mean, I knew, Joseph Smith sort of borrowed a lot of money and then, never paid back, where he bought land
and that's actually, that's another complicating factor, is that deed holders were the ones responsible for taxes, for paying taxes. And of course, that's how states and the federal government collected the majority of its income, was from property taxes. So you have a whole bunch of people buying up land on credit, right, not paying taxes for the land they're living on, and then the deed holders are not getting paid for their, the mortgage, and they're unable to pay with that mortgage the taxes for their property. Needless to say, it generates some hard feelings pretty quickly.
Yes, it does. And look, add the complication on top of that, deeds are required to be recorded.
Yeah.
Right. So you have to, like, when you and I have a contract, that doesn't have to be a matter of public record. So, it doesn't have to be notarized. We don't have to send a copy to anybody. We just, eventually, if you sue me, then, the document itself comes into evidence. And, but property, right, has to be recorded with the government. Well, we take that for granted in an era of computer technology where you can go and search. But, like, searching land records in the 19th century was and most of the 20th was a full-time profession. So
that's what a lot of historians with, doctorates in history are doing today for local history societies, is just looking through and categorizing and indexing land deed records and census records and just stuff that, now we can just Google it. People, all that information has to get thumbed into a computer manually right now. So it's like, it was a little bit more labor intensive back then.
Yes.
All right. So next question, and this is also related to Joseph Smith, eloping laws. This is from Walker as well. Were there any laws about eloping in this era versus social norms of the times? And this is actually an interesting rabbit hole, I thought. But Andrew, your take first.
So I have to plead total ignorance on. I don't know anything about 21st century family law,
right?
Let alone 19th. If I had to guess, right, and I do because I'm on your show and I don't have any other opportunity, I would say that there would be, right, because women's status in 1840 was property, was
Right.
chattel, and so I cannot imagine it would surprise me if there were not uniform laws throughout the United States, throughout each of the states of the United States, because these would be state and local laws that were meant by men, here fathers, to protect their chattel, right?
Hmm.
That is their unmarried daughters, who were again. Let's be clear here. Who were assets at the time, right? They
Yep.
were sold for dowries in the noble Christian institution of marriage. So I don't know, but I cannot. I would be shocked if there were not laws preventing eloping. And I bet we could find, if we went and Googled it, not only those laws, but at least one that has something that seems like crazy penalties attached to it, right?
Right.
Because it's like horse thievery, right? Like it
Yeah.
would be, a severe economic crime at the time. And again, I hope it's clear from my tone that I do not endorse that. But
Yeah.
there you go.
So I couldn't actually find the legalities of eloping, but I did find an interesting blog post. So take that for what it's worth, about the ever evolving definition of eloping. The way that we use it today isn't exactly how it was used in the 19th century. And it was also often used to basically accuse a woman of stepping out on her husband, having an affair, saying
Mhm.
that she left somebody to elope with another person without getting an actual legal divorce, which does fall under adultery crime statutes, which were fairly ubiquitous at the time. So adultery was where the actual legalities that I could find, had anything to do with this, and punishments for that could be very severe, including extensive jail time and fines and uh, corporal punishment. So adultery, of course, had an interesting take, but eloping itself, I couldn't find anything about specifically the legalities of it. I'm sure that there would be, somebody who is specialized in this that, has written an article, but I couldn't find it in just some cursory looking.
So
Yeah.
I'll send you. I did a quick Google while you were speaking,
Okay.
and
I was
so
just trying to kill
find.
time, everybody,
Yeah,
just
yeah,
because I
yeah,
knew
yeah.
Andrew would come up with something.
And this is not great, but Find Law is a pretty useful non-lawyer reference, right? Like they lawyers contribute, and it's a public it's a public knowledge base. And this is a lawyer named Brett Snyder, who wrote a 2014 article, "Is it legal to elope?" So if you Google, and I'll send you the link, Bryce, if you want to put it in, but if you Google, "Is it legal to elope?" Brett Snyder, Snider, you will get kind of the contemporary law around eloping. And from there, it's really easy to back into, what the laws must have been in the 19th century,
Right.
where, uh, you're talking about differing states and jurisdictions in which you have differing age of consent laws, right? And so I recommend. So I'll send this out to you.
Awesome. Thank you.
In my view, that further kind of confirms the off the cuff speculation of, you bet.
um, so this is also related to this, and I'll have a little bit to chime in on this, but this is from Walker. He asks, what kind of power did women have in the legal system when trying to rebuff Smith's sexual advances? And he includes the 1828 Eliza Winters when she was age 16. 1830 Miriam was 18, and Rhoda was 20. Stowell, March 1832. Kirtland, Nancy Miranda Johnson was age 16 at the time. So especially over the 18 age threshold, which I think was 16 at the time. What kind of legal power did women have on this? Do you have any idea, Andrew?
So I want to be really, really clear here. This is a tremendous problem today, in terms of the existence of laws that are designed to protect women who are the victims of violence. And there is, I'm going to try the next time. I've got a spare minute when you're speaking to pull up the law review article analyzing the Violence Against Women Act. The Violence Against Women Act was passed under President Clinton and made it a federal offense to engage in certain behaviors, right? Certain violent behaviors. And that was struck down as unconstitutional by the Supreme Court in 2001 or 2002. The criminal provision of it, because under the Commerce Clause, right? And the analysis was this does not affect interstate commerce. This is really, you're taking a state law crime, and because lots of states are garbage states, you're trying to make it a federal penalty. And the Supreme Court, you could sort of see the Supreme Court saying, and you know, we sympathize with that, but this is just not interstate commerce. So you don't have the power to do it. The article that I have that I've used as a resource on VAWA details the number of women that have suffered violent rapes, sexual assaults, and I don't want to speculate on the numbers. It is a heartbreaking number, and so the answer is, if Joseph Smith were anybody, right? He has the literal stereotype of the name that you pull out of a hat. So I can't be like, if he were just a Joe Smith, but like, you know, I mean, if he were a Thomas Jones, right? Like, then his victims would have had virtually no power in the first half of the 19th century in the U.S. As it stands, you know, I mean, you saw what he got away with against powerful white landed property owning men.
Right.
So I think that's, you know, I think that's the answer. That the fact that things that survive euphemistically today, I think, are very, very strong indicators of what must have been happening.
Yeah. To add a little bit of contemporary on this, contemporary knowledge on this, there were at the time libel laws that were known as sexual slander laws. And there's a wonderful article by John S. Dinger, just this, I think it was in Dialogue, spring 2018, that discusses how these sexual slander laws kind of came to be. And they were initially formed to basically protect a woman's reputation when somebody would accuse her of, you know, of having an adult, you know, having an affair. And it just placed heavy penalties on somebody who would make those accusations because, of course, it was really hard to prove them. So it was initially created as a law to protect women, but then it came down to a point where men were using these laws, Joseph Smith included, in order to get away with having many concubines, right? Because if they were having these adults, or, you know, having these affairs, one or many of them, somebody may accuse them of having these affairs. They can say, what's your evidence for it? And if it's he said, she said kind of situation, it more often came down to the person who made the accusation being charged with sexual slander libel. So that definitely complicated matters, and it was a law that was, you know, used as a loophole for people like Joseph Smith to escape any actual legal prosecution under adultery laws. Yeah.
So two things here. First, the article I recommend, and I think you can find it online. It's from the Villanova Law Review. It's by Michelle Anderson, and it is a symposium on new voices on the new federalism. And here I'm going to read the top line from what Anderson says. This is 2001. 84% of women who were raped do not report. Imagine the average rape survivor. She has no bruises or other corroborative evidence. If she calls the police, officials tend to disbelieve her and encourage her to withdraw the complaint. If police choose to investigate, prosecutors may not indict because she failed to complain promptly enough, failed to resist her attacker forcefully enough, or failed to lead her prior sexual life virtuously enough. And let me extend off of the end of that. We have changes to the federal rules of civil procedure and the federal rules of evidence regarding introducing prior sexual history in rape cases. Those changes came about in the 1970s and 1980s.
Cool.
Yeah.
Cool.
So at the time, like, add everything on top of everything, right? Now, take an era in which there are no DNA tests, right? There is absolutely no way to confirm or corroborate or disconfirm a particular story, and if you manage to navigate all of that, if the evidence is so strong, then the other side is and will have the full sanction of the court to put your entire sexual history at issue. And so, think about 1850s America. If you have one act of sexual impropriety, the Joseph Smith's lawyer is going to look across the table and say, well, sure would be rough if all of the town of Nauvoo had to hear about how you've had the dalliance with so and so. And they would have every ability to introduce that. So, yeah.
And I find it remarkable too that the name Sarah Pratt is still held with revile in believing circles because of those issues.
Wow.
Yeah, and somebody who was buried in Utah. So her character was assailed by Joseph Smith in 1842, and now more than 100 years after her death, she is still accosted with these accusations. So cool. Nice. That's a bit of disturbing information, but thank you for it.
If you're not, and again, if you're not disturbed enough, there is a ProPublica article. It is from Ken Armstrong and Christian Miller from 2017. This was written in when we were dealing with Roy Moore having won the Republican nomination for the Senate in Alabama and almost won election to the Senate. And it tells the stories of rape victims, again, in 21st century America. And, things like there's a case study of a woman they call Marie, who actually she was 18 and she reported being raped. But one of the things that happens, right, is when you complain of a crime, you go through sort of multiple interviews, right? And so police detectives then, and I'm quoting from the article here, treated small inconsistencies in her account, which are common among trauma victims, as major discrepancies. Instead of interviewing her as a victim, they interrogated her as a suspect. Under pressure, Marie eventually recanted and was charged with false reporting, punishable up to a year in jail. The court ordered her to pay $500 in court costs, get mental health care for her lying, and go on supervised probation for a year.
Great.
2 years later, this was in Washington State, 2 years later, police in Colorado arrested a serial rapist and discovered a photograph of Marie, proving that he had raped Marie. So in other words,
Cool.
This woman brought forward the allegation and then was not only pressured into recanting, but was criminally charged, placed on probation for truly, for bringing a true account of violent rape to the Washington police. So anyway, I'm sorry, I didn't mean to go. Yeah.
No, and just to follow up comment on that, you said that article said about 84% of sexual assaults like this never go reported. And I'd be willing to bet that probably even a higher percent of them that are reported never actually get prosecuted.
Yeah, and
So
that's you just
yeah,
connected up those two in exactly the way that I was going
cool.
to. So that's
Yeah.
yeah.
Okay. Let's move
So
on to happier
yeah,
topics.
let's do alternate history of Joseph Smith.
Actually, no. Our next questions actually moved to civil rights era.
Oh, okay.
And these are actually a couple of really fun questions from Walker, as well as a couple of them that are somewhat related as well. I want to talk to you about the Equal Rights Amendment because the church is opposing that. So I think if we kind of tie the threads together of the Civil Rights Act and the Equal Rights Amendment, it's kind of a current topic of discussion right now. We can really dive into some interesting conversation here. And then we also had a comment asking about legalizing polygamy in way earlier in the show in the YouTube chat section. And I have quite a few questions about that I hope we'll kind of cap the episode off with questions about that, if that sounds good with you, Andrew.
That sounds great. So
Awesome.
where do you want to start?
So we have next question here. This comes from Walker. It says, were there any legal arguments against the church considering slander to make when in 1963, Ezra Taft Benson was saying that the civil rights movement is a communist ploy? And also, more contextualizing, Ezra Taft Benson, he wasn't prophet at the time. He was an apostle. He was also a member of the John Birch Society. So hopefully that offers a little bit of context of, his mindset, the radical right that he was a part of in the John Birch Society, lobbying to have In God We Trust put on our money and stuff. Could the church be, legally liable for slander in issues like this when one of their representatives was speaking out about these issues?
So the answer is no. And here's why. In order for something to be slander against a public figure, the statement itself must be provably false, right? That is, it must not be a matter of opinion. And it must be made under the New York Times v. Sullivan actual malice standard, which means that the speaker must either know that the statement is false when they made it, or they must be indifferent as to whether it is true or false. And what I always say when you think about the New York Times v. Sullivan standard is think about walking by the Weekly World News in the supermarket, which says, Hillary Clinton to give birth to baby conceived with Bat Boy, right? Like, and if Bat Boy impregnating Hillary Clinton is not enough for Hillary Clinton to sue the Weekly World News and get that off the stands, right? That's the threshold at which you need to be. The allegation that the civil rights movement and that Martin Luther King Jr. in particular were communists, were bankrolled by the communists, was a communist plot, was not only, I mean, this is a shameful legacy, was alive and well as a slander, and is probably still alive and well as a slander in parts of the American South today. When the United States government went to make Martin Luther King Day a federal holiday in, I believe, 1983, could be 1982. I'm doing this off the top of my head. Cut me a little bit of slack. Jesse Helms took Republican senator and avatar of evil, took to the floor of the Senate to launch a filibuster, which back then was not just, you said, like you had to actually do the Mr. Smith Goes to Washington. He filibustered making Martin Luther King Jr. Day a federal holiday in 1982 or 1983. And his justification was that
he was a commie.
He was a communist. It was actually Bob Dole, senator from Kansas, who took to the Senate floor as a Republican to say, this is just this is beyond the pale, and this is racist and awful, and you should be ashamed of yourself. Which, good on Bob Dole for breaking the filibuster. Jesse Helms was, of course, reelected to the Senate 3 more times.
Cool.
So
Steve King is still a senator of Virginia or whatever.
Iowa.
So yeah.
There are racists and monsters out there, but no. And look, like, having said all that, right? I would want to protect the opinion of somebody. I mean, this may differentiate me from some others, but like, if I'm glad we do not. Let me put it to you this way: in the age of Donald Trump, replace Ezra Taft Benson and the Mormon Church with any left-wing activist right now, and replace communist with fascist. Right? Like
Yeah,
I
that's it.
would not. I would not want to see like left-wing organizations hit with libel suits going, well, you have to prove that we backed Mussolini and it's like, no, dude, we're calling you fascist because you're aggregating power in the presidency and no one supports you and you're a demagogue, right? Like,
Hmm.
and so, so I come down pretty heavily on free speech. So,
Yeah. And
so that's
you
very,
as a host of a podcast, you probably don't want every time you say that Donald Trump is a criminally insane game show host, you don't want to get a subpoena, right? I mean, it's protection of free speech works. It cuts every direction, not just both ways. So
yep,
yeah,
yep.
that's one of those issues that's very complicated and has a long history of jurisprudence that kind of teases it all apart for good
Yep.
reasons. It's controversial.
Yep.
Similarly, this is another question from Walker, and I don't know about this at all, but he asks, did the 1966 NAACP case force the church to change its policy on blacks in the priesthood in 1978? And there's a 12-year gap here, but I don't know what 1966 NAACP cases there were. I was able to find a couple of them and send them to you, Andrew, but I don't know which one he's referring to specifically or the significance of what case that might be.
Yeah, I don't know to what he is referring. If I had to speculate, he might be referring to the decision that invalidated racially restrictive covenants in the sale of land. And I do not. Um, I apologize for the.
So while you're looking, I'll just riff a little bit on the time disparity, right? So when it came to passing Martin Luther King Jr. Day as a holiday, the church was vehemently opposed to it as well. I believe it was 1996 or something that the state of Utah actually ratified it and agreed. So these John Birch Society sentiments kind of plagued the majority of the leadership for many years and still do to this day, right? You know, the current prophet was born in like 1926 or something. So in relation to what, a single event, a single case that caused the church to change its stance and give black people the priesthood, it wasn't a single thing. It wasn't a single event. There was a lot going on. There was BYU being protested. There was Bob Jones University losing its tax exempt status for still having a segregated school. There were a number of issues. That the temple being built in Brazil and issues of how to declare people's lineages and patriarchal blessings, and the church is not having any leadership because there was so much, African heritage in Brazil. There's so many factors that played into it. If Andrew has found this case, whatever this is referring to, I assume that this was just yet one more straw added to the camel's back.
It wasn't. I knew the name of the case, right? Because it's a very famous law school case. It's Shelley versus Kramer. Famous for a lot of reasons that I'm going to talk about, but in particular, the prevailing lawyer was Thurgood Marshall. So you can imagine, right? I mean, this was his landmark victory. This was his first landmark victory. And I thought it was early. It was 1948. It was even earlier than I thought. So I would not draw a linear relationship with there, but I think it does kind of help kind of put things in context. So I'll explain, because I think it underlies what you said. For most of the nation's history, homes were not sold outright. Well, I don't want to say all, but for most of our nation's history, it was a common practice when you bought a home from someone else. In many cases, those you can buy a home, what is called in fee simple, which means you own everything. You've bought the whole thing, right? That's what we think of as buying things. But oftentimes when we buy real property, you buy real property with certain conditions that are attached to it, right? A really obvious example is, suppose you live back in a development and you own the driveway that goes out to the publicly owned road. somebody might sell you that house, but they might sell it to you with a covenant on it that says, oh, and by the way, you have to respect the right of way and easements for these other 6 people in the neighborhood to drive on that driveway out to the main public road. So in other words, you own the driveway, you own the house, you own the property, but you've bought it with a condition on it. And that condition says you got to let your neighbors use the driveway because that's the only way they can get to the street. And all of that is perfectly fine and, you know, well established in the history of law. Well, not hard to see where this is going. People would sell houses with the condition attached that says you have to not sell to one of those people, right? And it wouldn't go. You know, it would specify. You know,
no,
you
hey,
may not.
Our president's dad built an entire economy of, you know, apartments with these provisions written into them.
Yep. Yeah. And that's how long. So it was 1948 when it was first struck down. And what happened was the Shelley family bought a house, had a racially restrictive covenant in it, and then they were sued to be blocked from taking title. And they went all the way up to the Supreme Court. Thurgood Marshall, like I said, was their lawyer, which, you know, all things considered, you could do worse to have him as your lawyer.
Yeah, you could do Clarence Thomas instead.
And the Supreme Court said, look, even though these are private contracts, they do implicate the Equal Protection Clause of the 14th Amendment, not because the contracts themselves are with the government, right? Like that was the argument, but because you are using the power of state courts to enforce them. Right. And that's why it was really kind of a linchpin decision in the beginning of the civil rights movement, at least in the judiciary in the 1950s and 1960s, because before Shelley v. Kramer, and again, you know, I'm over generalizing here. You can find individual cases recognizing civil rights, but by and large, the idea was, nope, private contract from party A to party B, libertarian paradise, you stay out. And so put all of that together, and what you have is the Mormon church dealing with, in the 1940s, 50s, 60s, clearly shifting winds, going, hey, look, us being private, like that may not be the knockdown argument anymore. You know, that legal landscape is changing. And you've talked about this before, like the crazy method whereby, you know, you have to ascend all the way up through the various councils to become the prophet, right? Like basically the oldest guy left standing gets to run the Mormon church. Well, that by definition means you're not dealing with, you know, people who have their finger on the pulse of cutting edge society. So, you know, 1975 seems about right for people to be, you know, for 80-year-old men to be finally wising up to, you know, the trends in the law over the past 30 years. So that's a long way of saying no to your question.
Interesting. So this is also similarly related, and this actually came from Julianne in the YouTube comment section. Because 1978, there was a lot of issues that the church could have lost tax exempt status. Could the church today, this is from Julie, lose tax exempt status in the future for not performing gay marriage? There's some similar themes in that question, but also it's a slightly different. What's your take?
Given where the Supreme Court is right now, I do not think that will happen.
No.
And I don't think that will happen for a number of reasons. Number one, I think as early as the fall term of 2019, right? That is, and those fall terms decisions may come out in 2020, but you know, within a year, I think the Supreme Court could overturn Obergefell. And thus no longer recognize a right to same-sex marriage in this country. I am on the pessimistic end on that. I have well-meaning friends who are liberal legal scholars that tell me, oh, I'm crazy on that. My belief on that is based on the swing vote on the court right now is Chief Justice John Roberts, and go back and read his dissent in Obergefell. It is scathing. It is as animated and as passionate as I have ever seen John Roberts be about anything. And you have 4 hardcore vote, right? You have the dissenters and Gorsuch and Kavanaugh who have indicated in public that they would have dissented in Obergefell. So I think A, the Supreme Court is going to roll that back. I think B, we also live in an era in which the Supreme Court has been very, very active in recognizing institutional rights, right? We have the Masterpiece Cake Shop case, which which builds on the legacy kind of put into place from the Hobby Lobby versus Burwell decision. Those 2 cases are the first time in American history in which you will find the religious freedom of expression under the First Amendment vesting in a corporate body, vesting in an institution, right? In the company of Hobby Lobby or in the church of the Trinity Lutheran Church in Missouri, in the Trinity Lutheran decision. It's astonishing to me. And again, I had meant to say Trinity Lutheran instead of Masterpiece Cake Shop. But Masterpiece Cake Shop, continues to follow that trend where for 200 years in this country, when we spoke of religious freedom, that was the freedom of individuals. Corporations are not belief-holding individuals; they are profit centers. They are. So anyway, so for those, I could go on and at great length, but I think, and I guess I'll answer the third question. In a sane universe, you would have an argument, right, of whether churches are going to discriminate. To be honest, I think so long as there is an availability of secular alternatives, fine, let churches refuse to perform same-sex marriages.
That's kind of the thing, is where there's a fundamental difference when it came to race in the priesthood versus gays in the priesthood right now. Because it was like, we're not letting them into the temple. But now, like, you can get into the temple if you're gay. You can even perform, or you can even be sealed. You can perform all the ordinances, just not if you're having sex with somebody who's your same gender, right? So there are some similarities. There are also some differences, and there are secular versions of, like, religions don't hold the monopoly on marriage.
I don't want to lose my liberal cred on this, but like, I think it's perfectly reasonable for a religious institution to discriminate within the institution on the basis of its religious beliefs for things that are confined within that institution. Right. So in other words, right, it is discrimination against me if I go down to the local Lutheran church at the end of my block and apply to be their head pastor, and they say, okay, do you abide by the tenets of Lutheranism? And I go, no, man, I'm an atheist. And they're like, well, you know what? Like, we're not sure that is the highest job qualification for, being a pastor. And great, right? You don't want to perform that ceremony institutionally? Fine. So long as people have access to the legal protections, that's what I care about. So, so not even if the law was going to stay the same, but I am strongly concerned that the law will not stay the same.
Okay. So tangent, this is a listener Bryce B question.
Those are my favorite.
I'm curious, when it comes to the Supreme Court, this is an avenue of court packing that I'd like to explore very briefly, if you're okay with that.
Okay.
Because we kind of have this model right now, right? We have Thurgood Marshall, who was the first, African-American justice, and then he was replaced. It seems like, hey, you know what? The first black justice died. Let's be sure we find a black justice to replace him. So it's almost like that seat is reserved just for African-American, members of the Supreme Court. I wonder if there would be any possible way to pack the court to make it representative of the people, and then but at the same time, or pass a provision, have Congress pass a provision that requires the Supreme Court to be representative, which would therefore require it to be packed with people who are considered, minorities, not white people anymore. So therefore, you would immediately have to increase the number of African American justices to 2 or 3. You'd have to increase, you'd have to add Japanese American, you know, uh, Native American justices. What a novel concept. What do you think about that? And also, do you think that would kind of insulate it from being so radically shifting on these single swing votes that John Roberts currently is right now?
Okay, so there's a lot to unpack there.
Okay.
Um, the Constitution just vests the judiciary in one Supreme Court and such lesser courts as Congress may from time to time establish. So that being said, and it was the Judiciary Act of 1789 that created the federal judiciary structure, that created the Supreme Court. The Supreme Court has had varying numbers of members over the years. So you can, the reason why it is called court packing, you can just by legislation add new seats to the Supreme Court. You could not take away seats from the Supreme Court because the Constitution specifies that federal judges, Article 3 judges, shall have life tenure. So with that in mind, you would have to craft your legislation in such a way that made it clear that you wouldn't kick somebody off the bench, right? Once you're on the bench, and you can only be removed by impeachment for bad conduct. So those two principles. In terms of having a law that had a racial diversity component for the court, I mean, could never pass Congress.
Right.
But I want to entertain the discussion and say, and I don't know that I would favor that kind of an approach. I mean, I certainly favor the mindset that you've said that goes into that, because I think, like, the smaller the Supreme Court, like, the easier it is to have a lack of diversity of viewpoints and to get kind of caught up in groupthink. And that doesn't even have to be, sort of left, right. Like, I think you see that with the trends in the Supreme Court in criminal defendants' rights cases, right? Like, even the liberal members of the court, right? Like, Ruth Bader Ginsburg was probably not harassed by the cops much, when she was growing up.
Right.
But my friend Andre Davis of the Fourth Circuit was, right. He is an African American justice, one of my personal heroes, and he talks about how, like, to this day, he gets stopped for driving while black, right? Like, I mean, so I certainly get the spirit, and I would add that the notion of having what it strikes, where the analogy that it strikes me here, it's not perfect, but is worth kind of having a further discussion about, is to the Supreme Court's case. It's a mid-'80s case. It's called Batson versus Kentucky, and it was about the use of peremptory challenges, right? Which is when I'm a lawyer and when I have a jury trial, there's a certain number, they've been getting smaller and smaller, of challenges that I can make to jurors, where I can say, like, nope, don't like that guy, I want him off my jury. And the pattern for a very, very, very long time that still continues was using your peremptory challenges to strike African Americans from the jury when you were trying, particularly in capital cases, when you were trying an African American defendant. And the Supreme Court ruled that practice unconstitutional, right?
Good. Good.
So yeah, it is. And so if you think about that, right, that there is some notion in our judicial system already that, like, that's something that seems like it's technically neutral may not be, of your peers if you're using it in a racially divisive sort of way. That's what comes to mind. So so I love the discussion, and hopefully that gave you some meat for it. So
Okay. Yeah, that's very helpful. But just a thought exercise,
Yeah.
because I don't like the reality we're living in. Okay, so I wanted to also let's explore a little bit more modern day stuff, and this actually comes in the form of two different questions. So on the Patreon thread on patreon.com/naked Mormonism, of course, we have a question from Chris, who says, I was really happy there was a method for officially and easily resigning from the Mormon church through quitmormon.com. Is there a law that requires a way to officially leave a religion? I'd be surprised if the Mormon church is just facilitating resignations on their own, but maybe they are. Also, as a Mormon history question, how long has a resignation been a thing? Thanks so much. I love you guys. And also related to that, we have from Richard Peckjack in the YouTube chat. Why is the church submitting all of the quitmormon.com resignations through Curtin McConkie, their law firm? What's the motivation to pay their law firm for something they cannot stop? So kind of an interesting set of
Yeah.
questions.
Yeah. Do you know? I mean, some of that obviously, touches on the historical aspect. I can speculate on the legal aspect, but I don't know what you know about the historical part.
Yeah, historical. The people were required to when they were excommunicated from the church, they were issued a formal writ of excommunication from the church's high council, or just told to get out of here. Or when somebody would want to leave, they would either just leave, or there were some rare occasions where somebody would actually tender a resignation, even in Joseph Smith's time. But those examples were few and far between. They've obviously been much more ubiquitous going into the Utah era, when somebody would want to have recognition that they are leaving the church and therefore hopefully come under legal protections. Because if you just happen to speak out against the church, or you just left the church, especially if you had some kind of social clout and you were a threat in some sort of way, then good old Porter Rockwell or Bill Hickman could just show up at your house at night. So declaring that you're resigning from the church was as much of a public declaration that I'm leaving. Everybody pay attention to me, make sure that I don't disappear, as it was, telling the people that we were no longer a member of the club. And those kind of evolved into the 20th century to be what they are today. But yeah, it's understandable why it has been. Of course, it's a subject that I need to look into much further to give a much more informed answer. But
Oh
hopefully
no,
that's
but
enough for the historical precedent.
yeah, no, that is very, very interesting. So let me answer the question. There is no law that I know of, or that I could even conceive of, regarding procedures to register or deregister from membership in a religion in the United States. It matters in countries that do not have separation of church and state, right? It
Right.
matters in continental Europe. It matters in Britain.
Right.
Um,
Where you have to be
uh,
registered as a member of a church.
but not in the United States. And the reason, and I'm going to weave this all together, but the reason for that is, right, that the church is a private organization. And so think about it, like, if you suppose you joined, a local Sam's Club because you wanted to buy some, bulk toilet paper, or you joined a golf club in your area, and then you just stop paying their membership. Like, if they want to still say, hey, Bryce is a member, like, it's very difficult for you to be like, I am hurt by being identified as a member here, right? We go back sort of to the standing issue.
Right.
Inflating your numbers is something that could hurt the church, or could help the church. But again, the harm there is really not particularized, right? Like, it's a bad thing. Like, the reason, my understanding anyway, like I said, my wife is an ex-Mormon, and the reason for her submitting her resignation letter, and the reason that most ex-Mos that I know do that, is because they don't want the church to inflate the numbers, right? They're like, hey, part of your marketing materials are, we're the fastest growing church, and don't stop padding the books with me. I'm not a member. I want to
Right.
publicly be acknowledged as not a member. But I don't know. It would be super interesting to me to see a lawsuit if the church decided that they were going to refuse to do it, right? If they just wrote back and were like, yeah, we're going to call ourselves whatever the hell we want. Good luck, go pound sand. I haven't thought about this, but like that would actually be a challenging lawsuit. Now, why do I think? Again, because of the particularized standing requirement, right? Because you're not really saying I'm hurt by what they're doing. You're saying my secular interests are being impeded by the fact that they have this particular policy. And courts are like, hey, look, we exist to redress wrongs. We don't exist to, to further your secular interests. Now, why do they do that, and why do they run these through the church's law firm? Because of the Mormon, and again, I don't know this, but I would bet everything I have that it is because of the Mormon Church's policy on tithing. The way in which you get particularized injury is when somebody brings a fraud claim, and
yes.
even
That's another
a
question I wanted
public,
to ask you.
yep, even a public institution can be sued for fraud, right? So I say to you, or if I go to bring a lawsuit and I say I was a tithe-paying member of the Mormon Church for 30 years, but I was misled into that because when I joined, I said, "Hey, I can leave at any time," right? And they were like, "Yeah, what do you? Just in the cult? Like, come on, you can leave at any time." And now I tried to leave, and here's my letter saying, "Go pound sand." They lied to me. I want my tithes back, and I would take that lawsuit.
You would take that?
Oh, absolutely. The plaintiff has a slam dunk fraud case in that case, right?
Well, okay, so I want to explore that because back in 2014, this was a pretty big case, but this was in Britain, so it's not necessarily applicable here, but I think it's interesting. The British judge dismissed a person's fraud case against the church. They did just that. They claimed that you acquired that the church acquired the tithing through fraud, and that they wanted repayment or remuneration for the tithing that they had paid in. The judge dismissed it. Granted, that's Britain, like I said, but. Yeah.
So let me jump in. Without kind of simply saying, "Oh, it's Britain, they're weird, they don't count." Let me add, sort of flesh to the bones. In this country and in Britain as well, you are required to plead fraud with heightened particularity, right? So in other words, you have to identify the exact statements that were made to you that were false at the time. Then you have to show that you relied on those false statements. And then you have to show that as a result of relying on those false statements, you suffered the harm. So I could see somebody saying, "Hey, you promised me eternal life, and now I realize that's all bullshit. So you defrauded me out of my tithes and I want the money back." And yes, that court and any US court, and to be honest, they ought to, would then be like, no. Like, look, that's not, those statements are not legally fraud, for purposes of maintaining an action. So you can, and again, look, this is kind of the weird status of, religion and the law, like they're selling an imaginary product that we all have to pretend isn't the case. But you can, it's not fraud to promise people that they will spend 1,000,000,000,000 years worshiping Jesus. It is fraud to say, on earth, here is this thing that we will do. We will let you leave the church, and then not do it. So.
Okay. So I guess the question would be in the purview of like possibly a class action lawsuit for maybe historical issues, claiming that fraud has been committed against me. You convinced me a story of, Joseph Smith that is not true. And you did so all of these, 120,000 people who are subscribed to the ex-Mormon subreddit within the purview of like a class action lawsuit about fraud concerning history. Does that complicate things a little bit?
Yeah. So I wouldn't take that case either.
Okay.
And here's why. So let me tackle the class action part of it first. Because class actions are governed by Federal Rule 23 of the Federal Rules of Civil Procedure. And the way in which that works is when it is impracticable to join all of the parties who are injured together because they are too numerous, you may then appoint representatives that stand in their behalf and that sue on behalf of a class of all persons similarly situated. you tend, this is a weird thing in American law, and I think it's because of movies. We tend to think of class action cases as like giant, oil spill or toxic gas leak, or asbestos or whatever. But in fact, almost all of those cases are individual cases. There
Okay.
are, as far as I know, no class action asbestos cases, and the reason is because even though each person suffered the same wrong, right? That is the gas leak, the chemical dump, the use of asbestos, their injuries are particularized, are individuated, right?
Right.
So I, working the boiler room, have a shallow lung capacity, and fortunately I only inhaled a little bit of asbestos. You're next to me, you've got big robust lungs, and you've inhaled 3 times as much asbestos, and so you have mesothelioma and I don't, fortunately. So if we get lumped together into the same class, my injuries and yours are not similar enough for us to be, we've got to sue individually, right?
Okay.
Does that make sense?
Yeah,
So
no, thank you for educating me on that.
yeah. So the way in which class actions proceed today, almost all of them are the class actions that you see, that you'll get a notice in the mail, that are consumer fraud class actions, because there everybody suffers the same harm, right? So
Right.
for example, monopolistic pricing, somebody misrepresented and they overcharged everybody by 13 cents for every Pop-Tart sold. And so then you get the little notice that's like, hey, as somebody who's bought Pop-Tarts in the last year, you were
Here's your
overcharged
13
13
cents.
cents. Right, there you go. But we can do that because it's easy to track the injuries there, right?
Right.
Like
Right.
it's not subjective with your enjoyment of the Pop-Tarts. It is, you paid 13 cents too much for your Pop-Tarts. Whether you paid, right, the rates you pay on the West Coast for Pop-Tarts, or whether somebody from Missouri paid discount, right? It doesn't matter. They still paid too much for Pop-Tarts, right?
Right.
So number one, you couldn't do it as a class action, and number two, even in a fraud case, right? If there is, right, the question, you have to have said something false, either knowing it was false or below the standard of care for knowing that it was false, right? And so if these people have convinced themselves of a history that is bonkers and wrong, and like, you would have to prove that they know that the things that they're saying are false, and I think that's a way uphill battle, right? Like there certainly are some people that you read enough of their garbage apologetics and you're like, come on, dude, you know you're
Right.
right. And
And
all
those
of the
individuals, the thing is like those individuals can be employed by the church, but not necessarily represent or be acting and creating their apologetics as a representative of the church. Therefore, they don't bring the entire church into liability for possibly using apologetics in a way that's fraudulent, right?
yeah, and again, remember, like, you can't sue, right? When you sue an institution, you are suing its authorized representatives, right? So you have to have a direct line between the person you want to sue and the conduct for which you want to sue them.
Okay. So related to this also would be the Gwynn v. Church of Christ in Collinsville case.
Okay.
And there was a similar case, I believe, just a few years prior to that, that was in Mesa, Arizona, against the church specifically. But basically, from my understanding of Gwynn v. Church of Christ, this person was attempting to resign. They tendered their letter of resignation from a church that's not Mormonism. And then the church therefore went on and excommunicated them and didn't accept the resignation letter. This guy sued for $390,000 and was awarded it, because apparently the resignation itself is what is supposed to take precedent over the excommunication. So similarly, in 1985, this is the Norman Hancock lawsuit, Mesa, Arizona. And it's
Sorry, puppy got a chew toy. It's 11 it's 10:20 out here.
Oh, okay.
He's
We're
hungry.
getting pretty close to wrapping here. So the Norman Hancock lawsuit was one that similarly, this guy, Norman Hancock, he was excommunicated after he had submitted his letter of resignation, and he filed an $18 million lawsuit against the church on this. And from my understanding, the records would show that he resigned instead of that he was excommunicated. And I believe that case was settled. And there were also some defamation issues in the Hancock case. So obviously, if we're dealing with issues that have some jurisprudence behind them, like Gwynn v. Church of Christ or the Norman Hancock lawsuit, it would probably be better for this massive multi-billion-dollar multinational corporation to handle these issues through their law firm. That way, the quitmormon.com submitting or quitmormon.org submitting those resignations to the church's law firm. Therefore, they can evaluate each case individually to make sure that the person hasn't been excommunicated and is therefore or is on track to be excommunicated and therefore is tendering their letter of resignation and about to be excommunicated, which would open up the church to liability for this. That's not unbelievable. That would be, kind of possible. And it's just showing that the church is smart, right? If there's an issue that has a legal component, they're going to farm it out to their crack legal team.
So super quick review of both of these cases and what they have in common. Let's start with the Gwynn, that's Guinn. I didn't know either of these cases until 18 seconds ago. So take it with a grain of salt. But Gwynn versus Church of Christ of Collinsville in Oklahoma. And as you point out, there was no written opinion in the Norman Hancock case. But what both of these cases focus on, narratively, the Hancock one, so I'm less confident, but there's actually a Supreme Court, sorry, not a Supreme Court. This is, it is the Supreme Court of Oklahoma. So it's Oklahoma's highest court, state Supreme Court decision in the Gwynn case. That is an action for invasion of privacy and intentional infliction of emotional distress. I could go into each of that, but in both of these cases, it looks like that I was talking about suing for fraud on the tithing because that was the most obvious to me. This was about church discipline being handed down. Right. And again, different churches practice church discipline to differing degrees, but you can see how, again, the same principle would apply, which is, hey, if an institution is practicing an activity, here, church discipline, that is designed to cause me pain, right? Then they have a standard, right, a duty of care to behave reasonably in how they conduct that activity. And when I say, I want out of your club, you've got to let me out of the club, and failure to let me out of the club can expose you to tort liability when you're like, no, not only are we going to keep you in the club, but we're going to keep you in the club and then excommunicate you and tell all your family, like, right, you're going to outer darkness, and, they should, declare you persona non grata. And, this, as I'm reading the Gwynn case, right, like
that sounds like what happened to the person.
Yeah, it's fairly extreme in that case. We can't really know what happens, but the first link on Mormon Alliance, when I bring up getting their attention, the Norman Hancock case, talks about the request being overwritten, quote, if a bishop or stake president is considering bringing a member before a disciplinary council, name removal should not be used as a substitute or alternative for excommunication or disfellowshipment, right? So I should have, the takeaway from all of that is I went straight to tithing because as a lawyer, I'm thinking follow the money. But I also should have gone to potential tort liability for your conduct. Because again, all of this is fine when you're talking about a private club doing goofy things among your private club members, right? But once somebody wants out of your club, that's when
you let them out.
Yeah, that's when you get, and that's what the lawyers are clearly saying. Even though, like, I recognize McConkie as a long-standing Mormon name, right? Like, it's clearly intertwined. I was Bruce McConkie was one of them.
Bruce R. McConkie.
Yep. So I get that there's not a lot of independence between the church and its lawyers here, right. But I'm assuming that they are competent at least to render that kind of, and that's why you do. That's why you put that kind of a procedure into place to protect yourself from those kinds of lawsuits.
Right, and why you also call lawyers to be in your general authorities offices. Also, similarly, we didn't quite hit on this earlier when we were talking about Civil Rights Act, Martin Luther King Jr., the Equal Rights Amendment. Back in 2015, the church supported an LGBTQ protections bill. And this was for housing discrimination specifically. But now the church is currently opposed to the Equal Rights Amendment.
Yeah, you mean the Equality Act that just passed?
Yeah, sorry, the Equality Act. Yes.
Yeah.
So how do we tease this apart? How do we kind of wrap our minds around this and what seems like kind of a dichotomous legal stance here?
So here's the way to understand that. The 2015 Utah bill was Senate Bill 296, and it is a good bill, right? It is, and I could. I mean, I think my position on LGBTQ rights is pretty clear. It does not go nearly as far as I would like it to go, but it goes way further than any other state that is as red as Utah, right? So, for example, it defines within the text of the law gender identity as having the meaning provided in the DSM-5. Right, and saying it and adding gender identity as a protected class for discrimination in housing in Utah. That's a huge step forward. What made this an interesting compromise, and it was reported as a compromise, and usually I'm skeptical of those kinds of reports, right? Because the press loves to say stuff like that when when it isn't. What made this a compromise was it was really two provisions, right? The first was a broad-ranging provision that said this chapter, and it had a couple specific things, right? It had exceptions for dress and grooming, and you can see how instantly that could be a problem, right? It had specific exceptions for sex-specific facilities, right? And again, you can see how that would be a problem. But again, I think this is better than nothing, and I'm going to talk about that particularly in the context of the Equality Act in a minute. It then says, and these are so this is provision 1. Section 34A 5.111 says, this chapter may not be interpreted to infringe upon the freedom of expressive association or the free exercise of religion as protected by the First Amendment and Article 1, Sections 1, 4, and 15 of the Utah Constitution. Furthermore, an employee may express the employee's religious or moral beliefs and commitments in the workplace in a reasonable, non-disruptive, and non-harassing way on equal terms with similar types of expression or beliefs or commitments allowed by the employer in the workplace, unless the expression is in direct conflict with the essential business-related interests of the employer, and then may not discharge, demote, terminate, or refuse to hire any person or retaliate against, harass, or discriminate in matters of compensation or hiring any person otherwise qualified for a lawful expression or expressive activity outside of the workplace regarding the person's religious, political, or personal convictions. I read all of that. So that's kind of part 1. I read all of that as saying, hey, look, we're going to protect you from in housing and in employment discrimination from somebody saying, ew, you're trans, I'm not going to, right, we're not going to rent this house to you, we're not going to hire you.
Right.
That's an unambiguously good thing. The law then says, but hey, we want people who are members of a religion that has weighed in a bigoted way against trans people to be free to say, but by the way, like, I do think you're violating God's law, and right. And look,
we hate the sin, love the sinner, so that's legally protected.
And look, I will take that trade-off in Utah.
Yeah,
right.
Absolutely.
I would march in the streets against this bill in New York City. Right. I would march in the streets against this bill in a deep blue state. In a deep red state, I'm a believer in incrementalism, and I'm a believer in making lives better for trans women and trans men who are on the street right now because they are being denied housing. So,
because
so
what's the alternative is no protections at all.
That alternative is the bill gets voted down, right? That you know what the Utah the composition of the Utah legislature is. It does not have a lot of trans advocates in it. The second thing that made this really, really interesting. It's one of the first laws that I've seen passed in the past 40 years that has a non-severability clause. Usually, when you pass a law, you have the reverse. You have a severability clause. Like I talked about the Violence Against Women Act at the beginning of this episode. The crime portion of the Violence Against Women Act was struck down by Morrison v. U.S. in 2001. Other provisions of that act are still in place that have to do with enhancing federal criminal sentences, right? Those were severable. They were severed out from the law, even though parts of the law were considered unconstitutional. This law says the reverse. It says, this bill is the result of the legislature's balancing of competing interests. Accordingly, if any phrase, clause, sentence, provision, or subsection enacted or amended in this chapter by this bill is held invalid in a final judgment by a court of last resort, the remainder of the enactments and amendments to this bill affecting this chapter shall be therefore rendered without effect and void. So in other words, if any part of this, if the religious free exercise part is struck down, or if the accommodations part is struck down, then the whole bill goes away.
Oh, that's fascinating.
It's really, see, that's the right word there. It's fascinating.
Wow.
And it is meant to be a backstop against any court, right, in interpreting that law. And look, like, for purposes of interpreting freedom of expression under the Utah Constitution, right, the court of last resort there is the Utah Supreme Court. But for the purposes of interpreting freedom of expression under the U.S. Constitution, the court of last resort is the U.S. Supreme Court. This is meant to protect the law against a decision by either of those courts on either of those key provisions within it. Really, it's really interesting. And so
does that mean also, however, does that mean that it opens up the rest of the law to being
the rest of the law goes away? Absolutely.
So the rest of the law is vulnerable if there's any single provision in it that is ruled unconstitutional.
Correct.
So it's a stop loss for now. It's a Band-Aid bill.
Yeah.
And then they're going to rip it off and cut deeper after. What is the ultimate idea behind or driving that clause being included?
No. So, okay. I don't read that in a sinister fashion. Like I read that in a sincere and face value fashion, right? Which is to say, look, we passed this law to remedy a problem and to criminalize the worst kinds of discrimination. But we got there in a compromise fashion. And what we're not going to let happen, and this is 2015, remember, what they're thinking is Hillary Clinton is going to be elected in 2016. I know, me too. And Merrick Garland and another sensible mainstream justice would have been appointed to the Supreme Court. And they were thinking that the Supreme Court's religious jurisprudence cases might curtail and come the other way. And what they're saying is, what this is a disincentive to either side to bring a lawsuit challenging the other half of the lawsuit, because you're going to lose the whole thing.
Wow.
Right?
That's interesting. Okay.
It really is a compromise. It was. So now, how does that match up to the court coming out against the Equality Act now?
The church coming out against it.
The church, right? Yeah, sorry, malapropism. Number one, and by far, that's why I walked you through all of that. By far, the most salient difference is the composition of the U.S. Supreme Court at this point in time, right? They don't need to hedge their bets against a Supreme Court saying, no, your view of religious expression here is overly expansive and can't conflict, right? Because you can imagine a Supreme Court saying, this provision of the bill is null and void insofar as it suggests that there can be a conflict between equal accommodation in housing and sincerely expressed religious beliefs. There can be no such conflict because it is not a sincere expression of your religious beliefs to violate U.S. law, right? That's the kind of thing I might write if I were on the Supreme Court, which is never going to happen. But Flash forward to 2019, that's now no longer a risk. So the church has less of a reason to want to hedge against that. They can be more brazen because Donald Trump has stacked the Supreme Court with anti-LGBTQ activists. And let me, by the way, let me do 30, since I'm assuming, I know you know, but I'm assuming your listeners know what the Equality Act is. Here's the reason why the Equality Act is critical. The Civil Rights Act of 1964 protects against discrimination in housing, employment, and other matters on the basis of sex. And there is a split among the circuits right now as to whether on the basis of sex includes on the basis of sexual orientation, right? And B, gender identity and expression. The more well-reasoned opinions, there's one from the Second Circuit, Zarda versus Altitude Express, and one from the Seventh Circuit, Hively versus Ivy Tech. Those cases have made the very straightforward argument that says, look, regardless of whether the people who wrote the Civil Rights Act of 1964 intended it to protect gay and trans people, they clearly didn't, right? They didn't write it in there. They didn't think you cannot discriminate against someone on the basis of their sexual orientation without taking their sex into account, right? When I say, oh, I fired Bryce because he's sleeping with John, and then I say, oh, but I didn't fire Sarah because she's sleeping with John, I have now discriminated against Bryce on the basis of his sex, right? That the same conduct, sleeping with John, lucky guy, by the way, is grounds for terminating you, but not terminating Sarah. And the same thing, right? The same thing applies for gender identity, right? I fire one person because of how they present in the workplace, but I don't fire a similar person for wearing a dress and wearing makeup and having a female name, right? Like it's not hard to see that reasoning. There's a split among the circuits, and there's a Fifth Circuit opinion that says nope, it says sex. If you want it to say sexual orientation or gender identity, add those words. You didn't, so it doesn't count. And the case is now pending. Those cases have been consolidated, are pending before the Supreme Court, and it's going to go the other way. It's the court is going to endorse the narrow ruling. And so what that means is a lot of people think, oh, well, we have anti-discrimination laws. Anti-discrimination laws apply if you are a member of the enumerated protected class. Gender is in the protected class. Gender identity and sexual orientation are not explicitly within the enumerated class. And so what that means is in 30 of 50 states in this country, you can show up to work and your boss can say, and you have been there for a long time, and your boss can be like, you're trans and trans women are icky and get out. And you're gay and I don't like it. Gay people are icky. That weirds me out. Get out. And that is horrible rank discrimination of the sort that is why we have a fucking legislature. So that's why the Equality Act is important. I mean, the number of people that don't know that, that think that the Civil Rights Act, the Title VII of the Civil Rights Act of 1964 covers gay, lesbian, and trans individuals is pretty high, and so it's worth saying. There's an argument that it should, but that argument is going to get rejected by the Supreme Court, and that's why we need a bill. So anyway, sorry, I didn't mean to soapbox that. I care very strongly about this.
Well, because this, we spend a lot of time talking about, fun, wacky early Mormon history and legal stuff concerning Mormon history like this today. This is our friends. This is your friend of the show, Alice Ashton. These are people who I spend time communicating with on Facebook. These are friends who I meet at atheist conferences who are impacted by this. So yeah, I can see why you're fired up about it. And likewise, this there's just kind of a, I think everything that needs to be said has been said.
All right.
Okay. So, you know what? We're way over time.
Oh, shocker. I'm way over time.
Well, and we also, I promised at the top that we would broach the subject of legalizing polygamy. I I'm afraid that I didn't, I didn't anticipate for some reason that the questions that I had drafted up would go so long. Even in the email exchange with Andrew before, I'm like, here, we have a few questions. Hopefully this will get us through an hour and 15 to an hour and 30 minutes.
Let's do this. Can I make this proposal?
Yeah.
Why don't you and I do a Patreon only special at some point in the future and do it just on the question of polygamy, and I will give you what I think are the best arguments for and the best arguments against and where it's going.
Fantastic, and that will be airing after my interview with Mayor Dunya Jessup, who is
Awesome.
the ex FLDS mayor of Hilldale, Utah,
Oh, yeah.
who unseated the 10-year incumbent mayor, who is still an active practicing member, and that's going to be coming up on Glassbox Podcast in the coming week. So I think
Nice.
that's a fascinating subject, and it's a really interesting topic, and let's do that instead.
Excellent.
So with all of that, Andrew, of course, I really, really want to thank you for spending so much time with us, for answering these rapid fire, sort of, I guess, these lightning round-ish. This is lightning and slow motion round questions. And obviously there's just a lot to explore this, and you spend a lot of time with us for that. I want to thank you. Aside from opening arguments, if people want to get in touch with you, where can they find you?
Opening arguments is by far the best way. So that is, you go ahead, Google it. You'll get out there. It is at OpenArgs on Twitter. And if this is the kind of thing you like, then that's probably also the kind of thing you'll like.
Certainly. And it's one of those, the very few podcasts that's on my list that every time, as soon as the episode drops, I got to download it and it's playing in my ears. It's truly one of my favorites. So it comes highly recommended from not only myself, but from basically every one of my friends who listens to it as well, because it is such a fantastic show. And I think we have it on pretty good authority that Elizabeth Warren and AOC are avid listeners of Opening Arguments, although that is a bit of speculation on my part.
Thanks, man.
Thanks so much, Andrew. And thank you also to our panelists, everybody who commented in the comments section, all of our Patreon supporters who made this possible at patreon.com/nakedmormonism. And for everybody listening to this in the backlogs, thank you so much for joining us. Take care, everybody.
This was a blast. Thank you so much for having me on, Bryce.
Absolutely.